the topic of information management issues during mergers, acquisitions, and divestitures is a huge one. We could spend all day and just start to talk on the surface. So there's a range of issues that we could address. What I've been asked to do is to focus particularly on the due diligence side of the transaction. So what I'd like to talk about today is the importance of information assets. That won't take very long for this audience. And then I'm going to focus primarily on issues in due diligence, generally the due diligence process from a lawyer's perspective, and then the issue of privacy compliance during and post transaction, confidentiality issues, information system security issues, which is an increasing topic as increasingly more and more Calgary and Alberta companies are targeted with cyber attacks. And then we're going to talk about some software license issues and data rights. And this is a session for you. So if you have questions as we go along, please feel free to ask the questions, because likely somebody else has the same question. I've got a limited time in this format to try to cover these topics. And so if it's a complicated question, we may move it to the end of the session. So first, we're going to talk about the importance of information assets in an M&A transaction. So I'm talking typically from the perspective of the purchaser, but also you could just flip around the issue from the perspective of the seller in these transactions. Information assets are essential for a business. They support the ability to make decisions for future conduct, so you can determine whether or not you're in compliance with your lease obligations, for example. They support current operations, so technical information that allows you to understand your facilities and maintenance or other compliance obligations. And the records provide evidence of compliance and with your business activities. So, for example, the ability to support deductions or revenues from a Canada Revenue Agency perspective. So they're essential for ongoing operations, and they provide evidence to support past decisions or past conduct that you've carried out. There are three types of M&A type of transaction. One is an amalgamation, that is where two entities merge to become one, and we call it a merger or amalgamation. The importance of this is, think of two rivers flowing together. So all the assets of both parties end up in the resultant company. And that becomes important when we look at due diligence, which we're going to talk about in a moment. The second type of asset is a sale of shares, so that the ownership of the entity itself is acquired by the buyer. So the buyer gets everything that the entity owns. Again, that has different implications from a due diligence perspective. A third type of transaction is a sale and purchase of the assets. In this case, it's very important to focus on the individual assets that are being conveyed, being sold. And so that type of agreement typically has very detailed schedules on the assets that are being acquired. And so in the asset type of transaction, the seller continues to carry on business, likely with other assets, unless it's substantial sale of all of their assets. But the focus in the asset type of transaction is very much on those assets. So in a merger or amalgamation or a sale of shares, all the information assets that are owned by the seller entity are automatically acquired by the buyer. So the tendency is that there's less due diligence. What the due diligence in those types of transactions is generally to understand how the assets are organized, what the assets are, and to verify that the proper systems are in place. In an asset transaction, which is often common when a producer is taking a particular set of properties and seeking to monetize them, the focus is on the individual assets. So the due diligence in those cases is very focused on, do the assets exist, is there proper title, and what records support the ability to operate those assets. So let's look at some of the things that you think about in the due diligence process. As we said, information assets are increasingly important. Due diligence is a systematic investigation to investigate and evaluate a business opportunity, and you can do an infinite amount of due diligence. So a threshold question is, how much attention is going to be paid to the assets, particularly the information assets that support the transaction? The amount of due diligence effort that will be made is typically a decision made by the deal team, the management of the deal team, and it depends on the materiality of the transaction. So if it's a $30 billion transaction, they're less likely to look at smaller value type issues than if it's a $2 million transaction or $50 million transaction. So the materiality level will determine a dollar amount of what is important to look at, what kinds of issues are important to look at. The second, from an information asset perspective, is how important are those to the business? So in a typical sale of producing properties, lease documents and all the supporting documents to understand what the legal obligations of the owner of the property are in order to maintain those leases in good standing, that's quite important. So it's a matter that people will typically pay attention to. Another factor is the nature of the business, how sophisticated the client is. So in our discussion this morning, one of the factors is, if you've done a number of these transactions, you start to understand what you need as a buyer in order to make sure that you can successfully integrate the purchased properties into your business. And so if you can get more of that legwork done by the seller through the transaction, then it can make your ability to integrate the purchase more effective. Another factor is cost. The due diligence effort is a trade-off between trying to get more information about what you're acquiring versus the cost of gathering that information. And so it ultimately becomes a trade-off. And as I mentioned earlier, the type of transaction will determine the amount of due diligence. So if it's an amalgamation or sale of shares, then it tends to be a lighter amount of due diligence, more looking at the systems and title questions, whereas an asset transaction is very focused on the specific assets, because those need title and the specific assets have to pass. So why do we do due diligence at all? We're trying to confirm that the business is what it appears to be or what it's promised to be. We're trying to identify potential defects or risks that could kill the deal, that might be to such a level that the purchaser no longer wants to do to the deal or cannot accept that risk. You're also gaining information so that you can value the assets. You can assess the accuracy of the representations management has given you. Are they inflating the story, or are they telling you the unvarnished truth? It helps you to identify issues that you can address in representations and warranties, which are a means to allocate risk in the transaction, and where you uncover problems. Just like selling a used car, people kick the tire, complain about the tread. It allows you to get information that you can use for price concessions or other concessions in the transaction. And ultimately, the reason that a purchaser goes into an M&A type of transaction is because they've developed certain criteria around what they expect from the acquisition. And what you're trying to do through the due diligence process is verify that what you thought supported your business case for doing the transaction actually is the case. A good M&A negotiating team includes quite a number of people, each carrying out different roles. You have a business lead who's usually an experienced decision maker, who's able to make the risk, cost, benefit type of decisions that you need. You may have professional negotiators who've done many of these transactions before. You'll have representatives from your finance department, marketing and sales. You may deal with intellectual property issues, the legal department. You'll look at technical compliance issues, government regulations. Specialized management, such as information management, might be part of the team, particularly for if you aren't part of that team, you might talk with your legal department about what your needs are in these transactions so that the assets coming over to you or the records coming over to you are easier for you to integrate into your operations. Typically, there's a competition law assessment and tax assessment that are part of the team as well. All these people have to be coordinated, and they're typically operating under a cone of confidentiality. So each of the team members have to understand their role, what the time frame is to carry out their part of the due diligence, what the materiality level is, what mechanism there is to flag issues that come up through the process, how to log those issues so you don't lose sight of them. These M&A projects tend to be done under severe time pressure. You work very long hours. If you don't have some mechanism of keeping track of problems that you find or how you're going to resolve the problems, you'll tend to lose them. You need a reporting mechanism, and as I said, this all is carried out under secrecy obligations, so that they'll typically be for the transaction, just to evaluate the transaction, a form of non-disclosure agreement or a similar type of agreement that will ensure that there's confidentiality both from the buyer side as well as the seller side, and deal with what information can be shared and in what circumstances. There will be limitations in those secrecy obligations. We'll talk about that a little bit. So we've talked about due diligence a little bit. The amount of due diligence depends on an assessment of the business and the degree to which the data is an important part of the business, and also the extent to which it contains sensitive personal information. Typically what we would do is interview the target staff and review internal policies. So we're looking at issues like privacy compliance, document retention policies, software licensing policies and the agreements. We want to see IT security and other policies that might be relevant to the particular transaction. We want to see that the policies are current, whether they're being applied. We want to see what happens when policies have been breached, and are there third-party claims that might be part of the transaction. Again, in an asset sale, the lawsuits may stay behind, whereas in a merger or acquisition or a sale of shares, you're acquiring the company, including its liabilities, and so you, in those kinds of cases, you're more concerned about the litigation. So you're trying to assess how effective the business is in compliance with all of the various regulatory and other obligations it has. So the key issues that you can focus on, and there are many issues, as I said, is privacy compliance and the requirements of privacy law during the due diligence process, confidentiality, information system security, and software license issues. So these are the things I'm going to spend a couple minutes on. As many of you should know, we have mandatory private sector privacy laws in Canada, and in Alberta we have a provincial law called PIPA, Personal Information Protection Act, and we have a federal law called PIPEDA, which has been in place now for about 16 years. And every organization is obligated, unless there's an exemption available, that our system is based on consent, So we need to collect personal information, and we can only do that if we obtain the consent of the person. And in your records are lots of personal information. So you have information on landowners, information on particular problem cases dealing with individuals that might affect the organization. So you have obtained that personal information typically on a consent basis. You can use the information only for the purposes for which the consent was given. You have to destroy the information after the purpose has been fulfilled. And our law requires that the individuals can challenge the accuracy of the information or access the information you have on them. We don't see a lot of access or complaints in the oil and gas business because, again, most companies are prudent and responsible and careful with the personal information in their custody. But these obligations do create compliance obligations for each organization. So unless an exception applies, how do you even share the personal information for the purpose of due diligence? And so to share information for the purpose of due diligence, you have to have obtained consent. That's either express consent, so that's explicit consent, like you sign with the bank when you sign forms to open an account. There's deemed or opt-out consent. An example, unless you advise us otherwise, we can use your personal information in the manner described in your privacy policy, or it can be implied by conduct. And I would suggest many of your consents are implied by conduct. So when you gather information on landowners, on individuals, trust information about wills and estates and the like, it's inherent in a particular transaction, so you can use it for the purpose of that transaction. The question before you share any information for the purpose of due diligence is it reasonable to say that the disclosure, transfer, or exchange with a third party as a result of a sale, merger, grant of security, or other transaction was one of the purposes for which the information was gathered? If not, then you can't share the information. You may have to get an additional consent. So here's an example of a problem. During the .com era, a company called ToySmart developed quite a large client list, and part of their privacy policy said that they would never share the information with a third party. The .com bubble burst. The only asset left at the end of the day in bankruptcy was the customer list, and another toy company wanted to acquire the list. The Federal Trade Commission intervened and said, you can't do that because you promised you'd never share the list. Ultimately, a variety of safeguards were developed that did allow the list to be shared. But the point is, your privacy policy can actually impair your ability to do an M&A transaction, because often people put these kinds of motherhood statements in their privacy policies. So to get consent from all of the landowners to do an M&A transaction, to either carry out due diligence or to fulfill the transaction at the end of the day, is too onerous and impractical. There is an exception for business transactions, and it allows the sharing of personal information during due diligence subject to some safeguards. The federal law, PIPEDA, was amended in 2015, and they introduced a business transaction exception. It allows the organization to share personal information without an individual's consent for the purpose of engaging in due diligence for a prospective business transaction, where the information is necessary to determine whether to proceed with the transaction or to complete it. So in due diligence, typically due diligence isn't going to be looking at all of your land files, but there might be some sampling of particularly important lease documents to look at whether they're in good order. There must be, for this exception to work, you have to have an agreement so that the buying organization or the prospective purchaser commits to use and disclose the personal information solely for purposes related to the transaction, you have to protect it with adequate safeguards, and you have to return it or destroy it within a reasonable time if the transaction does not proceed. And that typically, as I said, is in the non-disclosure agreement or pre-transaction agreement with other binding terms like confidentiality. The agreement also has to address conclusion of the transaction. So once the transaction is concluded, the organization, the buyer, can now use and disclose the personal information without knowledge and consent of the individuals involved. Again, if it was needed to carry on the business that was the object of the transaction, so the new owner of the leases needs that information to be able to operate under the lease, provided that the information is used and disclosed solely for the original reasons it was collected. So you can't use that information to sell an additional service or to monetize the information. You have to provide adequate safeguards, and you have to honor any withdrawal of the consent of the individuals. Alberta has had a business transaction exception in place since 2004. It covers all categories of personal information, and again has to have the same types of covenants and safeguards that you saw under the federal law. British Columbia also has a business transactions exception. It's narrower than Alberta's exception. It's limited to employees, customers, directors, officers, and shareholders. The agreement has to, like Alberta, contain some covenants and undertakings, and in British Columbia you have to give notice to the people of the transaction. So these transaction exceptions impose limits on what information can be shared, how it can be used through the due diligence process. The next topic we talk about is confidentiality. All businesses manage confidential information, the information of your own business records, business plans, financial information, and the information of others. So you can acquire confidential information of third parties, and you owe obligations to those third parties. Employees are entrusted with this information, so all of your confidential information typically leaves the office at 5 o'clock in the afternoon and goes home. And so that's a risk for every organization. And so you typically protect the organization with what we call a trade secret protection scheme. You segregate third-party information from your own information so you don't mix it, so you can comply with your obligations. You have adequate confidentiality terms in your employment agreements, agreements with consultants or others. Before you give access to your confidential information, you bind people who you're giving access to. You educate people about their confidentiality obligations. You monitor compliance with those obligations. You're prepared for enforcement action because you can lose the ability to protect your secrets once they're misappropriated, unless you take action. And then you have to pay particular attention to ongoing obligations to third parties, particularly in collaborations. So in many cases, you'll be involved in joint ventures where you're working with other parties and you are sharing confidential information back and forth. You have obligations to protect their information, they to protect your information, so you need to pay attention to those obligations. In an M&A context, you will exchange confidential information through the due diligence process. And again, there will typically be an agreement that sets out the aspects of the confidentiality obligations. What information will be protected? Are there formalities required? So is the information going to be exchanged, going to be marked confidential, or is everything that is in a data room considered confidential? There will typically be two types of restrictions: a restriction on use of the confidential information for any purpose other than carrying out the due diligence, and there'll be disclosure restrictions, so you can't take a juicy piece of information and talk to others about it. You should address the sharing of information or the creating of information. So typically the fact that you have access to records means that you may take notes or create your own files about the due diligence process. So you'll typically address that. You'll also address how long these obligations should last and what happens on expiry. So there shouldn't be a free-for-all to be able to use the confidential information on the expiry of these obligations. What are the duties? What gets returned, or is it destroyed? And how do you deal with electronic copies, which are always a problem because it's hard to delete electronic documents from particularly email systems. If there's no confidentiality, a court may imply it. And the problem with implied obligations is we don't know the scope of the obligations. So the International Cronin Lac Minerals was a case that went to the Supreme Court of Canada. A junior mining company found gold and didn't have the resources to be able to develop a full-scale mine, so they started joint venture negotiations with a senior mining company. There was no non-disclosure agreement or confidentiality agreement in place. The junior mining company said to the senior mining company, we think the adjacent property to the property we've staked, called the Williams property, is likely to be fruitful, and we want to stake that. The joint venture never proceeded. The senior mining company staked the Williams property. It was Canada's biggest gold mine. So the case went to court, and had any of us at the time seen the information about the junior mining company's claim, we could have gone to the minerals offices and staked our own claim on the property adjacent to it, and we probably wouldn't be at a information session in the Petroleum Club this morning if we'd done that. We didn't do that, so we're here. What the court said was, while the information on what the adjacent properties was not confidential, the intent of the junior mining company to stake the claim was confidential. The Supreme Court found that the senior mining company had violated an implied obligation of confidence and ordered the transfer of the mine. By this time, $1 billion had been spent on the mine, so less the value of the improvements. Ultimately, the parties settled, so it was a huge judgment. So the important point is, what you think is confidential may actually be relatively trivial information, but it'll be strongly protected by the courts. And here you have an M&A context where you can see the importance of confidentiality in these discussions, because information gets shared, and if it's misused, the courts will take action. The next topic that we'll look at is information system security. The Ashley Madison hack was very conspicuous and public, drew a lot of attention to these risks, and it impacted a planned financing. However, most cyber breaches are not publicly broadcast. Most attacks are done secretly, so that if you've been hacked, you may not know about it for months or years. And the issue is that undetected hacks can go on for a long time. So Yahoo recently announced it was hacked, 500 million records compromised. It was actually hacked in 2014, and it appears they only discovered it 2 years later. These attacks are happening in Alberta, so lots of ransomware attacks. The Privacy Commissioner said recently they believe there are about 6 Alberta attacks. A very public one just a couple of months ago was the University of Calgary. So this is a business. The criminals that are carrying out these attacks are looking to extract ransom, and they're targeting people who have defects in their security policies or their security practices. The problem in an M&A transaction is The damages or consequences arising from a breach are hard to predict. You may not know the scope of what's been compromised or the total liability. So for lawyers, this becomes a problem because our traditional boilerplate representations on confidentiality, privacy, and intellectual property may not be sufficient to allocate that risk or to address the risk. And so particularly if the information or the target of an M&A transaction is information rich or particularly sensitive, then the risk is highlighted. And so this is a new risk that we ought to be paying attention to. What level of security is in place? So what can we do? Identify and manage the cybersecurity risks during the negotiation and due diligence stages of a transaction. So one of the issues is you're keeping the transaction team under a cone of silence because share prices can be manipulated if people become aware of a transaction that may be going ahead. Focus on the representations in the transaction, particularly where representations talk about compliance with industry standards. Industry standards in cybersecurity are changing quite rapidly, and so you need to be clear what an industry standard really means. Your team will focus on the indemnity and limitation of liability provisions and things like caps on liability in the context of security breaches. You'll define the exposure to the risk. So when has a breach occurred? So if you were in a transaction to acquire Yahoo, which of course is in the news today, that transaction is at risk because of this breach. The question would be, who's responsible for cleaning up the breach? At what point does the responsibility shift from the seller to the purchaser? If you're concerned about these risks, you can do focused due diligence and assess the security of the target's practices. And if it's really a significant risk, you can consult forensic experts to be able to assist with this kind of due diligence. So again, from a due diligence perspective, when we're looking at information system security, we'll interview the staff, we'll look at the internal policies, we'll make sure IT patches are being applied. If businesses do nothing else but make sure that their security patches are up to date, that can really reduce the risk. Because the way these criminal enterprises work, they look on the net to see announcements of a new breach. So if you read the news this morning, Microsoft has a problem with Windows, and so Microsoft is looking at putting a patch together. If you're a criminal organization, you look for who has the particular program and can I access that breach. All the information will be available on the internet. And so when the patches become available, apply them so that you keep plugging the holes. When we look at due diligence from a security perspective, we look at, have there been past intrusions? How did the target respond? Were their practices improved because of that experience? Is there litigation? There's a wealth of breach litigation going on in Canada right now. So it doesn't have to be a hack. It could be that somebody misplaced a laptop with sensitive information and it either got stolen from a car or was otherwise lost. And then we look at how prepared is the organization in the event of a breach or incident. Do they have a response team? If there's more comfort needed, then we can do follow-up with cloud services. So many of you may be using cloud-based services. The issue with that is you don't know who's actually providing the service, because the cloud provider is usually providing you an application. You want to know where the servers are located, who's providing the facilities, who's providing the various layers of software that support the application. And is the host, say Amazon Web Services, what's their experience with breaches, and how secure are they? What are their practices and what standards do they carry? Many very sophisticated cloud service providers will commit to third-party audits, so you can see those audit reports. So if security is important to you and it's a cloud-based service that is being provided to the target, then you can review those audit reports. So typical due diligence we'll do is to look at the license agreements, the service agreements for assignment restrictions, unusual terms, business restrictions. We'll review privacy compliance, but we can also look at these other issues of risk to data centers, disaster recovery plans, privacy and IT policies. And I'll conclude by talking a little bit about some software license issues, because increasingly we are in an electronic world and your records are being managed by a variety of different sophisticated information systems, and you need those operational records to be able to operate. And you need that irrespective of which software platform is being used. So one of the threshold issues is what software is the target using to manage its records, and what software is the acquirer using. Are the data files compatible with each other, or is there a data conversion issue going on? Key things that we look at are who owns the intellectual property in the data files. The way the copyright rules work is, unless you have an agreement to the contrary for you to own the intellectual property, the contractor will own the copyright in work they do for you. So typically when you're having data conversion done work, that's done by independent contractors, so you pay attention to those issues. Other issues we look at are is the target using freeware or shareware? And we need to know what those license terms are, because some licenses can be viral. If you bring that license into your organization, it can affect your ability, particularly if you use a lot of software. What rights do you have to use the data or the software? What commitments do you have to the different vendors? Are there exclusivity obligations that you have? And for the licenses, we talked about looking at assignment restrictions, change of control restrictions. What's the scope of the grant? What can the target do with the software, assuming the software is coming with the transaction? And is it limited, for example, on a per seat basis or by the size of the business? Can you actually use the software legally in the merged business? Again, are there exclusivity obligations, and on what basis can it be terminated, and what's the term? So we look for restrictions or aggressive terms in software license agreements, and it's not unusual to find those terms in software license agreements. Very often companies don't pay attention to these licenses and don't negotiate them. So there'll typically be a requirement for consent to assignment or an ability to terminate on change of control. So the software itself may be a situation where you have to pay an additional fee just to continue to use the software as the acquirer. And that's typically the case in many seismic data license agreements. There's typically a restriction on the scope of use, so it might relate to your level of production or the number of files or the number of staff who are using the software, and so additional fees may be required if you're combining that software or using that software in the acquired business. And a really problematic trend that we're seeing is software companies seeking to own your records or asserting rights to be able to use the information in your records, so that you're in a situation where you may not have an ability to transfer the electronic records without an additional consent, which usually means a fee. Another problem is that if you are the acquirer and the seller has its records on a particular system and is selling that business, you may not want to use their software. You may have your own, but very often that means that the license will be terminated, and on termination, very often there's obligations to delete the data or not to be able to access or use the data. So you have to think through those issues and make sure that when the seller sells a particular set of assets and turns off their software, you want to be able to make sure that you've got the business records that you need in order to be able to continue to operate the assets. And so you may want the seller to maintain its license rights until you can be satisfied that you got all of the assets that you needed.